The duty of care in tort law is a really large and complicated area with lots of cases. But in this short lecture, I want to give you a brief outline of what the history of it is and what the duty of care actually involves and how can you apply it in an essay or a problem question. Right, let's get started. The first person to come up with the idea of having a duty of care was Master of the Rolls Brett in the case of Heaven and Pender in 1883. But obviously the most famous formulation of the duty of care was Lord Atkin and his neighbour principle in the case of Donoghue and Stevenson 1932. I've put the full quote there for you to read in your own time, but essentially what Lord Atkin is saying is that we should treat people as we would want to be treated ourselves. So this is not really too different from the biblical principle of the Good Samaritan or even Kant's categorical imperative for those of you who know a little bit about philosophy. So that tells us about the duty of care itself, but we also need to know in what type of situations the duty of care should actually apply. In one of the first key cases on opening this up, Lord Wilberforce in Anne's and Merton London Borough Council 1978 said that policy arguments should form the central idea behind this. In other words, if there was a good policy reason to establish duty of care, then one should exist. Now, this led to a huge opening up in the type of situations where a duty of care could arise. And so we have cases like Junior Books and Veitchi from 1983 that even established a duty of care for cases of pure economic loss. Now, obviously this opening up couldn't go on forever and it had to be restrained by the courts. And so one of the first cases where this restraint was applied was in Hill and Chief Constable of West Yorkshire Police in 1988. In this case, they said that there has to be at least a relationship of proximity between the claimant and the defendant for a duty of care to exist. All of these principles that were tied up in Anne's and Hill and some of the other cases throughout the 1980s came together in Caparo Industries and Dickman, and this is still really the test or the case that we use for establishing new duties of care. In other words, there has to be a relationship of proximity between the claimant and the defendant. There has to be foreseeability between the defendant's actions and the claimant's injury. And thirdly, it has to be fair, just and reasonable to impose a duty of care on the defendant. This third element of fair, just and reasonable is something of a hark back to Lord Wilberforce's arguments in favour of policy, but it's applied in a much more limited way. Nevertheless, it is applied, and we can see that it is applied in cases such as Mark Rich and Bishop Rock, which was a 1996 case. Here there was a policy reason for not imposing a duty of care on a non-profit organisation because that would encourage defensive practices. And so we can still see the importance of policy, but it's no longer at the centre of establishing a new duty of care. The standard to be applied in a duty of care is that of the ordinary citizen or the man on the Clapham omnibus. In other words, just a person like you or me. And if you're anything like me, then you're probably not a professional at anything necessarily, and so you're only expected to be reasonably competent at something that you're doing, as in the case of Wells and Cooper, 1958. And there's also a recognition by the courts that ordinary people do make errors occasionally. The Ogopogo 1972 is an example about a boat accident in Canada, and there was a rescue attempt made, but people sort of botched this a little bit. There was argument there that there should have been a duty of care and that people should have been up to this reasonable standard, but the court said, well, you know, these emergency situations put a lot of pressure on people and it is likely that you are going to make a mistake, and so there wasn't a duty of care in those types of situations. While we're on this, it's worth mentioning that people like St John's Ambulance or rescue emergency responders could be held to a higher duty of care, but even in those situations, the courts are keen to encourage people to help others out and try and react in those emergency situations. You essentially don't want to establish a too high a level of a standard, because you don't want to discourage people from helping those in need. So to what extent is this a variable duty? Well, with children, there is a bit of variation. In McHale and Watson, 1966, this is an Australian case that involved a child as the defendant. The two children were playing and one of them got badly hurt by the other's actions. And so the question was, well, should we apply the standard of a reasonable adult or the standard of a reasonable child? And they said it was unfair to hold a child up to an adult standard, and so the duty of care or the standard required was that of the reasonable child. In a converse to this situation regarding children, in Latham and Johnson, there was the argument made that if you are being held responsible for a child, so if you're a carer, for example, or a parent, then there will be a higher standard of care for you because you are responsible for this child. However, it could also be seen that there is a general duty of care and that this objective test of the reasonable citizen does apply generally. And there's no greater example than this than looking at drivers. So in Nettleship and Weston, this was involving a new driver who had not been on the road very long, only a few weeks or so, and they were involved in an accident. And they said, well, the standard that should be applied to me is just the reasonable person who has only been driving for a few weeks. But the court said that the fact that you're on the road and are a road user driving a car means that the objective standard still has to apply. It doesn't matter whether you've been driving for 3 weeks or 30 years, we still have to apply that same standard of the ordinary driver. Similarly, in Broom and Perkins, the ordinary person should always take precautions. This person had diabetes but didn't take their medication, and they eventually had a diabetic attack while they were driving, and so they were still held up to that standard that the ordinary person with diabetes would take reasonable precautions before setting off on a journey. So that's the standard in general life, but what about for professionals? Well, professionals are held to the standard of a normal person in their profession. And so one of the common examples would be doctors. But there is still an understanding that things like medical opinion can vary between doctors. Some doctors may do things in a certain way, other doctors may choose to do it in a different way. And this was recognised in the case of Bolam and Frion Hospital 1957. And if the doctor can prove that what their actions could be justified by a large body of medical opinion at that particular time, then they would evade liability. And this sort of test of making sure that there is a professional body of opinion that supports their actions has even been applied outside of the medical profession in some situations as well. So in Carty and Croydon London Borough Council, this involved special educational needs, and it can be seen that the Bolam test, as it's called, can also be applied to local government in some situations as well. If there's a large body of opinion that supports the actions of the defendant, then they will be able to evade liability. Now, we have to also analyse the risk that takes place. The Hand formula comes from an American judge, Justice Hand, who basically said that there will be liability on the defendant where the burden is less than the possibility of damage occurring multiplied by the loss incurred. Now, this is a little bit complicated to understand at first glance. So if we go through each of the 3 elements that I've highlighted there, we can explore it in more detail. So let's look at the burden first. This is the burden that exists on the defendant to avoid the risk in the first place. So in Latimer and AEC Limited, there was a slippy floor in a factory that someone slipped up on. They made a claim, And the argument relating to the burden was that in order to avoid this possible risk of a person slipping on the floor, the burden on the defendant would have been too great. They would have had to have shut down the entire factory to avoid this risk occurring. The court agreed and said that this was too high a burden on the defendant to avoid the risk. Moving on to the second bullet point, the possibility of damage. If it's very unlikely that damage would actually occur, then we can avoid the liability in that situation as well. So in Bolton and Stone, this is probably one of my favourite cases because it involves cricket, and if you read the judgment you can tell that the judges also liked cricket, and so the cricket club won. But essentially what happened was a batsman hit a six into the street and it hit a person in the head. Now, obviously this is not a very good thing to happen. The person was seriously injured and put a claim in against the cricket club. But the judges said that the likelihood of that damage occurring was very small. They looked at the figures and saw that only 6 sixes, these big shots that go out of the ground, had been hit in 30 years at the cricket club. And so the possibility of this damage occurring was very slim. It was less than a 1% chance. And so that's a factor that they have to take into account. Finally, we also have to look at the loss from the claimant's point of view. How much has this damage that they've suffered actually affected them? So in Paris and Stepney Borough Council, we have a claimant who only had one good eye, and they were set to work at a metalworks, I think it was, but they weren't given a pair of goggles. And you know what happens next. He is involved with an accident and he loses the sight in his one good eye, and so he becomes completely blind. And so what the court said here was that the loss was particularly great, because if it was someone with two eyes who lost their vision in one of their eyes, that would obviously be a bad thing. But for a one-eyed person to completely lose their vision is a huge loss indeed. And so this is another variable factor that we have to take into account. So if we think back to the original formula, I've put a case here at the bottom that we can actually look at to sort of go through this in sum. In Haley and London Electric Board, Haley was a blind person who was walking along the street. There was an open manhole cover where the electricity board were working, and Haley unfortunately fell down the manhole that was unguarded, and he lost his hearing as a result of this. So if we apply the formula, the burden on the electricity board was very small, because if they just put some simple fencing around the manhole which was open, then they could have avoided this risk entirely. So the burden was very small. We can look at the possibility of the damage. Well, it's likely that someone who was blind could fall down the manhole, but even your normal passerby who's not paying attention or not looking where they're going could still have suffered damage. And so that possibility of the damage occurring was relatively high. Finally, with the loss, we have someone who is already blind, and similarly with Paris and Stepney, Haley loses his hearing on top of being blind, and so this loss that is incurred by Haley is particularly substantive in the circumstances of this case. So obviously the electricity board was found liable in these circumstances, and we can see there how the hand formula operates in reality. Finally, we can look at the burden of proof, and this is on the balance of probabilities. Would the damage have occurred? Has the duty of care been breached? And so to put that in numerical terms, we're looking at a 51% chance or higher that the breach of the duty of care by the defendant caused the loss suffered by the claimant. And one other final thing before we go, res ipsa loquitur is something that's used in establishing this burden of proof occasionally in tort cases. It's a Latin phrase that literally translates as the thing speaks for itself. And in this type of situation, we're looking at circumstances where the defendant is managing a particular area where the claimant has had their accident. And so the argument follows that
even if it cannot be established essentially that the duty of care has been breached in evidential terms, the thing speaks for itself in that the claimant had the accident there and the defendant was responsible for managing that area, and therefore it can be said that the defendant was responsible for the claimant's accident. A good example of this is Ward and Tesco stores from 1976. In this case, a yogurt had been spilled on the floor of a Tesco supermarket. The claimant had slipped up on that and they automatically blamed the store manager and Tesco in general. The claimant tried to argue res ipsa loquitur, in other words, I was in your store, I slipped on a yogurt, you were responsible for managing this store, therefore you are to blame. But the courts actually said in this case that we have to be very careful in applying res ipsa loquitur. It can't just be a simple way for a claimant to establish a case without actually proving anything. It's not something that can just be used easily. It has to be applied in a very careful manner, and only where the claimant cannot establish the case in any other way.
When you're answering a tort problem question, the duty of care is one of the first things that you should look at. In order to do this, you should first establish who is the claimant in the case and who is the defendant. Once you've got an understanding of this, you can begin to apply the Caparo test and work out whether it's actually fair to apply a duty of care in the case. So we can look at foreseeability, the proximity of the relationship, and also whether it's fair, just and reasonable to apply a duty of care. Once you've done this, you can go on to look at the objective standard of the reasonable man and apply that to the defendant. And also consider in more detail the hand formula that we discussed, looking at the burden on the defendant, as well as the possibility of damage occurring, and the loss that's been suffered by the claimant in the case, balancing all these to try and come to a decision on the balance of probabilities, before you actually go on and look at the other factors in tort law, such as causation. Well, thank you very much for listening to this lecture. If you did enjoy it, remember to leave a like and subscribe for more videos in the future. Any questions at all, leave those in the comments below and I'll make sure to get back to you. Thanks very much for watching. Bye!